Good afternoon, everybody. We have people in person, which is fantastic, in the third floor of the Capitol building, and we have people that are attending remotely. Just a brief introduction. For nearly 50 years, the Friends has been a leader in working to protect the boundary waters and to connect people of all backgrounds to the wilderness so that this and future generations benefit from this special place. I'm Max Kiley. I'm legal director at Friends of the Boundary Waters. And with me today is a special guest, Evan Nelson. Evan Nelson is a phenomenal person, a board member at the Friends, and an even better attorney. Evan's part of the Maslon team, along with Margot Brunel, William Pentlovich, and others that have been entirely representing the Friends in the courts against Polymet. Two preliminary matters. Before we get started, I want to thank some partners that we have in this fight. The Friends need friends, and the Friends are proud of the friends we have. And we'd like to especially give recognition to our partners in the fight against the Polymet project, including Maslon, MCEA, Water Legacy, the Center for Biological Diversity, Fond du Lac Band of Lake Superior Chippewa, and everybody here in person and attending. We appreciate everything that you do. Today's webinar is being both live streamed and to a remote audience and presented to a smaller live audience. Feel free to raise your hand, ask questions. We'll do our best to try to get every question answered. If you could go to the next slide, please. Sure. So just to center us here, what we're talking about, we're here to talk about the Minnesota Supreme Court oral argument about the MPCA's wastewater permit. Up on this map, you'll see a red dot for Polymet, yellow dot for Twin Metals, if you can see that. Twin Metals is on the doorstep of the Boundary Waters, in the Boundary Waters watershed, about 12 miles to the southwest in Polymet. It's at the headwaters of, the major tributaries to the St. Louis River, which then feeds as a major freshwater source to Lake Superior. Next slide, please. So before we get going, Evan, I was wondering if we could take a step back, right? How did we get here, right? Obviously MPCA issued the permit in 2018, and like most, permits that are being challenged, Friends and others initiated the certiorari appeal. And then something went a little weird at the Court of Appeals, and the Court of Appeals transferred to the district court pursuant to a section 1468 hearing. Can you provide just a little background about how rare that is and what exactly was pointed out, and sort of talk about the district court and then the Court of Appeals, just set the stage for what happened today.
Sure. So as good afternoon, everybody. Thank you for taking the time, and the people here in the room, again, thank you for coming today and being the support. I can definitely feel your support when I'm up there, and it's very helpful. In this case, and in almost all cases, what happens is the agency will issue a permit to the mining company, and then people can challenge the permit. And they're challenging the permit for being insufficient under the law, for not being protective as required by Minnesota statutes or by federal statutes. And then what happens is all of the record the agency considered is brought over to the Court of Appeals, and the Court of Appeals just looks at that record and says whether the issue or the permit is good or not good. So there's a record, the agency record. Now, in this case, and this rarely happens, there was significant evidence that part of that record was missing because MPCA took steps to make sure that EPA comments didn't come in. And the EPA comments would normally be part of that record. So because there was some allegations at the time, just some evidence at the time, the Court of Appeals took the step that they can take under statute and sent the entire case to a trial court. And we had a trial about whether the record was complete and whether there was any actions taken to make the record incomplete. Max said this was rare, and I just want to underscore how rare this is. As lawyers, we often look for precedent, right? We look for other cases that similar things have happened because we want to educate ourselves. Well, what have judges done before? We could barely find any precedent that dealt with this situation. I mean, barely anything that dealt with this. We found one case where the Minneapolis City Council took away a liquor license. That was the main case that we were working off of. And so this rarely happens, or maybe it does happen a lot and it's rarely caught. But in any event, this is a very rare situation. So we had a 2-week-long trial at the trial court to talk about this record and whether it was complete, which the trial court said no, it is not, and whether there was intentional actions by the PCA to make the record incomplete, which the trial court said yes, there was. There were intentional actions on the PCA's part to make this record incomplete. So then that's the order in 2020 that the district court came out with. And after that, we took that newly completed record up to the Court of Appeals.
Yeah, and you know, that district court order that was issued in September 2020 was frequently the court was referencing, you know, certain findings of fact, right? And that's from the district court's order. In 2022, so this goes to the Court of Appeals, right? And you know, the Court of Appeals reversed and remanded to MPCA, but otherwise upheld the permit, right? Or otherwise upheld all other arguments that were raised.
Right.
Can you explain what the Maui functional equivalent analysis is and why the court remanded back to the agency?
So a couple of vocabulary things that we'll think about here is what is reversing, what is remanding, what is affirming, what does all that mean when you're talking about appellate courts? Because that's what we're not talking about trial courts, we're talking about appellate courts. So in an agency review decision, you take that record to the Court of Appeals, and if the court affirms what the agency has done, they essentially find there's been no legal irregularities with what the agency has done. That's affirming. If there's a reversal, that's essentially vacating the permit. Permit does not exist anymore. It's been erased, and that's called reversing. Remanding is the act of sending the case back to some other court or to some other agency. So if it's been remanded, that means this entire case is going back to the trial court, or this entire case is going back to the agency. So what the Court of Appeals did in 2022 is they said, we are going to reverse and remand on what's called the Maui analysis. And the Maui analysis was a United States Supreme Court under the Clean Water Act that said the agency needs to analyze whether a discharge would be the functional equivalent of a discharge to surface water of the United States.
And just to clarify, discharge to groundwater is the functional equivalent of the discharge to surface water.
Thank you. Because essentially what the state of the law before was, there was some ambiguity or some questions about whether if I discharge into groundwater and that groundwater is 3 miles away from the nearest river, does my discharge to the groundwater impact that river? Because the Clean Water Act talks about waters of the United States, and that's streams, rivers, everything except for groundwater, right? So the Maui analysis is that the agency has to understand whether the groundwater discharges are the functional equivalent of a discharge to the ground to surface water. That was never done in this case. The PCA's position was that we don't have to do it. The United States Supreme Court came out and said in a different case, in the County of Maui case, agencies have to do this. And so the Court of Appeals said, well, because Maui says this, then so it is here. And that was the first reversal. And they affirmed everything else. They affirmed everything else about this permit. They affirmed the process that was undertaken by the PCA. They affirmed the groundwater rules under Minnesota. They affirmed the decision to not have Q bells. Everything else was affirmed in the Court of Appeals decision. So then after that, I'll let you take over.
Yeah, and you know, you heard Evan talk today in court, and maybe in the preamble to this about, you know, the tailings basin, right, and the permanent stockpile, and that makes up about 2,000 square acres.
2,000 acres.
2,000 acres, right?
All acres are square.
Yeah, and so, and these are designed in a manner in which to sort of allow the pollution to be released and then hopefully capture it. And this is the exact type of, functional equivalent or the chemicals, the pollutants that we're talking about that the MPCA needs to undertake a functional equivalent analysis.
That's correct. Yeah, yeah.
And so after the Court of Appeals issued its decision in 2022, Friends and others, filed a petition for further review, or PFR. And can you give us a sense of how frequently these are granted? I mean, just to give, everybody, we're not just coming here because everybody gets an opportunity to come to the Supreme Court. It's a rare instance.
That's right. In Minnesota, you do not have a right to have your case heard by the Minnesota Supreme Court. It's actually the same thing at the federal level. You do not have a right to have your case heard by the United States Supreme Court. You have to, in essence, ask for permission. And the Minnesota Supreme Court has this process by which we ask for permission. I don't have numbers, but I can say that's also very, very rare that they will take a case. In fact, in the other challenges of the Polymet mine, we've had one other case that was brought up to the Minnesota Supreme Court. I think
one's in briefing now.
One's in briefing now, so two, but there's been like what, 7 or 8 challenges total that we've had. And several of them, if they don't accept your petition for review, whatever the Court of Appeals said, that's the law. That's what you're stuck with. So we petitioned for review, saying that this is an issue of statewide importance. That's the consideration. We have to convince the court in the first place that this really honestly isn't about Polymet. This is about the state of Minnesota. And this is applicable everywhere else, to every other mine, to every other agency. That's why this is important. And so the court granted our petition, which then allows us to bring the case to this court.
Yeah, thank you for the background, Evan. And, if anybody has any questions, again, virtually or in person, feel free to raise your hand or type in a comment. Next slide, please, David. So this sort of sets the stage for today, right? And the arguments that were raised today. One more, please. So Friends, the band, Water Legacy, raised, I would say 3 broad issues today, right? The MPCA EPA document suppression issue, the Q-Bells issue, and then the groundwater issue. And I think, I sort of view these as the Q-Bells and the MPCA rule prohibiting groundwater discharge are more substantive permit term challenges, whereas the MPCA EPA suppression is more of like a procedural issue. So let's handle the MPCA EPA comment suppression argument first, right? I think it'll be helpful to break down for our audience, what happened? What did MPCA actually do? What did and how did that result in potential prejudice to Friends, Water Legacy, the band?
Sure. So let me preface this by saying this is what the trial was about. And I want us all to remember that there is a difference between what we know and what we can prove. And so I'll talk about what we've proved in the trial court. There's lots of stuff that we know that isn't really part of this record. The PCA is supervised on all Clean Water Act permits by the Federal Environmental Protection Agency. In fact, the Clean Water Act authorizes the EPA to be the regulator and then lets EPA delegate that authority to states so long as states essentially behave themselves. I don't think there's been any state that's had that revoked. I guess Wyoming, but that's a guess.
Yeah, I think I recall something. Maybe it was in the clean air context.
Yeah. So that's why EPA is important here, and MPCA knows that EPA is important. EPA is the parent, and PCA has to behave. And so when this Polymet project was first proposed, and when the permit was actually the draft permit was issued, what happens is PCA will take a look at the project and say, here's what you have to do. You have to have liners over here. You have to have control over here. You have to have effluent limits over here. That's the permit. They published a draft permit, and that happened in early 2018. And then during that public comment period, after it's been published, we all can comment, friends commented, Water Legacy, the band, MCEA. I'm sure several of you submitted individual comments. And PCA knew that EPA was going to comment during that period because they had all of these phone calls back and forth in which EPA was saying, here are some of the current concerns that we have with the permit. So what happened was towards the end of the public comment period, the political heads of the MPCA understood that EPA was going to submit comments. One of the PCA staffers called an EPA staffer and said, is there some wiggle room on this? That's a quote. That's not me paraphrasing. He said, is there some wiggle room on this? And what they didn't want is they didn't want to have EPA comments actually written and submitted during the public comment. They did that, those comments. And if they would have ignored the comments, then that's ammunition for us to say the permit is bad because EPA thought it was bad and you didn't do anything about it. Or even if they thought that EPA was right and changed the permit, like, right, there's any number of things that could have happened when EPA submits that comment. They didn't want that at all. And what we proved at the district court level is that they did that because they didn't want to have bad press. Sidebar question. Why should PCA care about bad press for a project? Why is that a consideration? There's no reason why PCA. Right. It was bad press against Polymet.
Yeah.
I mean, imagine all those high school hockey tournament people going would be all of a sudden confused. I thought Polymet was a good guy. They've been supporting hockey all this time. That was sarcasm for those of you watching at home. So what they did is they first asked the scientific staff to not submit comments. And Kevin Farrar, the head of that scientific staff, said, no, I'm going to submit comments. They then went above Kevin Farrar's head and went to the Trump-appointed politicos at the EPA. And they said, hey, you guys, could you guys go ahead and not submit comments? And they did a good job covering their tracks. A lot of this was done over the phone. But there was a few emails here and there. One email from the commissioner of the MPCA directing his assistant commissioner, go ask the EPA Trump appointees to not submit comments. And then one email from the assistant commissioner to the Trump appointed person from EPA to say, hey, we don't want you to submit comments right now. Can we have a conversation about it? And then after all that's done, there's another email from the Trump appointed EPA. His name is Kurt Thied, who said, we're going to delay submitting comments and we'll take a look at this extended period of time you've given us to look at the permit. The first two emails I described, in which the commissioner asked his subordinate to go do this, the one the subordinate asked EPA, those were destroyed by PCA. And what happened was the assistant commissioner, who was given a state issued, like you guys paid for it, laptop. When she left, I'm just going to delete some emails because it just makes it easier for you guys if I delete some emails. But she didn't delete a whole block of emails. She went in and deleted some individual emails, and those are the two that she went in and actually deleted. Well, I mean, she deleted more than that, but she did delete those two, but she didn't delete the ones in which the EPA said, we're going to delay comments and we'll take a look at this permit over the longer period of time that you've given us. So that's why we were saying today that what was proven is that there was evidence that PCA took actions to not have EPA comments come in, and that evidence was destroyed. And the district court found that that was unlawful. So I forgot what your original question was.
Yeah, just let's, talk about that issue.
Okay, yeah, yeah.
So I think you've done a good job unpacking that. Do you think it's too in the weeds to talk about the difference between unlawful procedure versus arbitrary and capricious conduct as it relates to the MPCA EPA common suppression?
Yeah, I think that actually one thing that's really important for all of us to understand is at the Minnesota Supreme Court and also at the Court of Appeals, you're asking legal questions. And those legal questions are framed by statutes usually. And that's what we're here for. So Minnesota statute 14.69 is part of what's called the Minnesota Administrative Procedures Act. I'm going to call it MAPA. Okay, MAPA. MAPA says that a agency decision can be reversed and remanded. In other words, a permit can be reversed and remanded if some person's substantial rights may have been prejudiced by the decision. And then it lays out in, I think, 6 different categories of what the court looks for to say if there's been some sort of prejudice. And one of them is if the decision is unconstitutional. One of them is if it was based upon unlawful procedure. Another one is if the decision is arbitrary and capricious. Okay, the other ones aren't terribly important, and neither really is the constitutional. So remember how I said earlier that we have this record, and normally you just look at the record. So what they do is they take a look at that record and they ask themselves, there's something about this record that shows that the agency's decision was unlawful, based upon unlawful procedure. Or something about this record shows us that something in the decision was arbitrary and capricious, right? Well, if it goes back to the trial court, like I said, that's actually under a different statute. And this is why people hate lawyers. This is under section 14.68, and section 14.68 says that the trial court there is to determine whether the record is complete because of irregular procedures. So 14.68 says the trial court is looking for irregular procedures, and 14.69 says the appellate courts are asking whether the permit was based on unlawful procedures. So lawyers being lawyers, we spilled thousands and thousands of words to argue about what the difference is between irregular procedure and unlawful procedure. That ultimately today wasn't a terribly important question. I think there might be some justices who were somewhat interested by it, but at the end of the day, I don't think that they were, because there were findings of the trial court that there were violations of the law with the destruction of that evidence, right? There's an Official Records Act that says essentially if you're the government, you got to keep everything you ever create in writing. And then there's laws against what's called spoliation of evidence. If you know that something is evidence of some import to somebody else and you destroy it, that's against the law. Classic example for spoliation would be throwing a gun in the river, right? So those laws were violated. We had unlawful procedures, so we didn't have to, argue about that too much.
And we will jump into some of the questions the court asked, but just very briefly, the chief judge, I think she made a couple points about MAPA, right? And at one point, I think early on, she said that this is clearly, the conduct is clearly in violation of the intent of MAPA, right? It's arbitrary and capricious. But then she later said something along the lines of, how is this not a hard law? Yeah. Right. So how do you reconcile those two positions?
So the policy of MAPA is actually stated in a statute, and the policy of MAPA is to encourage confidence in the government's decision making through transparency. Look, the government's going to make decisions we disagree with, but the thought is, as long as they're upfront about the reasons for why they did things, then we can live with it. We don't want to have decisions being made behind closed doors. That's the policy behind MAPA. And so what the Court of Appeals said, actually what the district court was implying a few times, and I think what Justice Gilday was referring to, was that there's really no doubt that when NPCA knew that comments were on the way, and they would have been part of the record had they arrived, and they took steps to make sure they didn't arrive, that's contrary to the purpose of MAPA. That's anti-transparency in government. right? That I think is where she was going.
So would you say she was, just to expand on that point, would you say she was then using MAPA as an unlawful procedure, right? As opposed to, the broader arbitrary and capricious standard within 14 points?
She may have, I think the court will probably not make that ultimate ruling. And the reason is because courts don't usually want to say that violating the purpose or the policy behind a law is the same thing as actually violating the black letter of the law. The thought is that usually that winds up being too broad and it makes too much behavior illegal. And there's enough laws as it is. We don't need to make more things contrary to law. And so that, I think, where she was maybe driving at that, and why she wouldn't ultimately say, even if it's against the policy, I mean, shame on you, PCA, but they have to point to something else to get the relief that they want.
Were you surprised today that there was sort of no action on the actual prejudice versus potential prejudice? And several justices talked about it's a question for remand, right?
Yeah, I was very surprised about that. So the statute says that reversal is warranted if our rights may have been prejudiced. And what the Court of Appeals did is they quoted that statute, and then instead of may, they took out the word may with 3 little dots. And so they changed the statute to reversals warranted if substantial rights have been prejudiced. You can hear the difference between those 2 sentences, right? What they were saying at the Court of Appeals is that we had to prove to actual factual boots in the ground prejudice. And we had to say, we were going to do X, but couldn't because of what happened, right? But the statute is much broader than that. And really, I think that all the parties kind of conceded that the Court of Appeals made a legal error with those 3 dots. And I think that the court understands that as a legal error. So what we're really talking about is, did PCA's or any agency's conduct create the potential for prejudice, which is actually much broader than did they actually prejudice.
And you sort of felt that tension today, right? Questions like, well, how do you know what EPA would have said? How do you know what the outcome would have been if EPA commented?
Yeah,
right. So, and I think you did a great job today, Evan, obviously, in answering those types of questions. So, if anybody has any questions on the suppression issue, otherwise I'll move on to the 2 other issues that are sort of more substantive.
If I can actually just say the last thing that I think the best way to conceptualize the potential prejudice as we see it is that because of PCA's actions, there is a known unknown. They have created a black box, and that black box is how they would have responded to PCA's or EPA's comments. We know that we don't know it, and that's where our potential prejudice lies. And I think that's the problem. You don't want to have agencies being able to do that, regardless of what you think about the mine. You simply don't want agencies with the power to take away questions they don't want to answer.
Yeah, and more to that point, and I think this was from a point that the band raised in its brief, but the band argued that there was prejudice in the sense that MPCA said, hey, it's not a big deal. EPA's comments weren't in, but they were duplicative of all, other public comments. But when EPA makes a comment on something, that's entitled to deference, right? And MPCA can't just, brush that aside. Whereas if, somebody, a regular citizen makes that same comment, MPCA can come in and say, we're entitled to deference. That's just, we disagree with that. That's not helpful, right? So, all right. So moving on to the next 2 issues.
I see a question of them.
Okay.
Actually,
Let's see
if I can
pull I've got it right here.
Oh.
It was someone asking about the distinction between the prevention of water pollution and mitigation of pollution seemed really crucial. Will the Supreme Court use the stricter standard in this case?
And that question comes from Paula. And actually, that's a great transition, Paula. Thank you for the question to what Max is going to talk about next.
And so we're going to talk about sort of 2 issues, the need for QBELs or water quality based effluent limits and the violation or alleged violation of MPCA's prohibition against groundwater pollution. But I think some background might be helpful, like just if you could, Evan, just some of the high level dangers of copper sulfide mining, brief overview of how the wastewater treatment system works with the tailing basin and the permanent stockpile, right? Very, very high level.
Well, I can only go high level on that kind
Yeah.
of stuff. So that's good you're asking it that way. So copper sulfur is bad. The real problem with the specific mine that's being proposed here is the insidious nature of the pollutants that we're talking about. We're talking about pollutants that accumulate over time in waters and accumulate in fish tissue, which then transfers in up the food chain. And I'm talking about mercury specifically there. When it comes to copper and sulfide, we're talking about pollutants that really can't be cleaned. They once they're out and once they're exposed to oxygen, the chemical reaction cannot be undone. And you have a pollutant that cannot be mitigated against, other than to essentially just say that that area is off limits. So that's the issue that we're dealing with here in terms of what pollutants we're talking about.
Yeah, and just to sort of supplement that, obviously when polymet and twin metals, they're seeking to, go after disseminated copper, right? It's just ribbons of ribbons within rock. So they literally have to pull up hundreds of tons to crush that reactive rock, right? In order to get their precious copper. And the question is, what do you do with that rock, right? Where do you put it? And that sort of leads into just a brief overview of Polymet's wastewater treatment system, tailings basin, and permanent stockpile. There's, I think, 4 different stockpiles from 1 to 4 based on how, for lack of a better word, how dangerous the rocks are, right?
Right.
4 is the most dangerous, down to 1, and some of the more dangerous piles do have liners, right?
Yeah, so this mine site, and there's essentially a 2,000-acre area that's going to have a tailings basin, and that they're going to put finely ground tailings or leftover materials after the precious minerals have been extracted. The fine tailings will be put into this basin and essentially buried under a lake. But there's no liner underneath that lake. There's nothing to capture the seepage, and just normal hydrostatic pressure will push water that contains these materials into the groundwater underneath that tailings basin. There also will be a large, and when I say large, I'm saying 500-acre, 200-foot high pile of waste rock, like just huge amounts of waste rock that will be there forever. And there's no liner under that either. And that waste rock, which had previously been buried under the earth, has been exposed. Oxygen has mixed with the materials inside the waste rock, creating more problems for pollution. As Max said, there are other stockpiles because the Polymet has categorized 4 different levels of how dangerous or how much pollutants would be caused by these waste rocks. The stockpiles of category 2 and 3 and category 4 waste rock will A, be lined, and B, will not be permanent. The plan is to not have those things last forever. The category 1 stockpile is a new mountain made by Polymet that is meant to be there forever. And the tailings basin is an expanded lake made by Polymet to be there forever. And all of that will be on 2,000 acres. And as I said today, and I think it's important to contextualize this, 2,000 acres is the state capital times 2,000. We're right now sitting on an acre of land, and 2,000 of those is how much groundwater will be polluted. And around that, they've built what they call a containment system, which essentially is a huge kind of concrete barrier that's going to go down and supposedly key into the bedrock, and then will stop the water from getting outside of that containment system, will percolate up, and they're going to treat it and take the pollutants out and then discharge the supposedly clean water from that groundwater into the groundwater around that area. So set aside any skepticism you may have about whether the containment system will work. That skepticism is warranted, and that skepticism will be part of that Maui analysis I talked about before. Okay, so that question is still out there. Our argument today was that the groundwater rules of the state of Minnesota say that you cannot discharge into groundwater. And the system that I just described to you intentionally discharges into groundwater. The only way that it doesn't violate the rule is if you think those 2,000 acres don't count. And in their brief, and actually in the permit, they described this 2,000 acres as a small and contained area. Okay, so you can see what they're doing, right? You can see they're drawing a ring of hope around this permit, or around this mine, and they say we hope that nothing's ever going to get outside of this ring, and we're just not going to think about what's inside that. This, by the way, is the exact same agency that penalized a homeowner for spilling oil in his driveway because there's cracks in his driveway and the oil got underneath his driveway into the groundwater. That's what, 1/10 of an acre that someone's house is, right? So the same agency that thinks you can't do that thinks you can go ahead and pollute these 2,000 acres because we hope you'll collect them later on. And so our fundamental argument is that the rules do not allow for this whatsoever. Another thing that helps us in our argument is that the rules themselves have what's called a variance procedure. And the rule says if strict compliance with this rule is not feasible, you can request a variance. This is actually very standard rulemaking for construction projects, for zoning, for anything else. There's a variance procedure, right? I looked before, I looked again last night to make sure I wasn't wrong. There's no variance procedure in this project. I did a control F for variance, not there. I at one point read this entire, 600-page long permit. There's no variance at all. So we say that this permit on its own terms violates the rule against discharging into groundwater. And there were questions from the justices, if I can just go ahead and jump to that.
And not only any rule, MPCA's own rule.
Yeah,
right?
that's exactly right. The Minnesota Pollution Control Agency itself issued this rule in the early 70s. And when it did so, it had a fairly lengthy statement of need for the rule. And when it did that in the early 70s, it was saying, we understand that groundwater is probably the most important resource that the state of Minnesota has for now and for future use. And they said in the early 1970s that there is nothing but increasing demand for groundwater. And they also said there is nothing but increasing threat for groundwater. And so therefore, with all of that going on, we want a rule that will prevent new pollution into groundwater. And we'll try to mitigate and clean up the existing pollution at the time. Now, at the time, perhaps the biggest problem in the state of Minnesota was the creosote woodpile in St. Louis Park, which has since become a Superfund site on which I live. So they actually mentioned that in the rule, like how important that was, but we should mitigate against that. We should clean that up. We should mediate that pollution. But new pollution, we want to prevent it because groundwater is just simply too important. Now, fast forward to, was that 45 years since the early 70s to now, they just didn't follow that rule. And the Court of Appeals, in its opinion, did somewhat of a two-step to ignore the problem with the permit under the groundwater rule. They said, well, if you read the rule, it's actually kind of ambiguous. There's a lot of ways you could read the rule. And when you have an ambiguous rule, what you do is you say, is the agency's interpretation of its own rule reasonable? Okay. Everything I just said, by the way, that's what the law says. But the problem is, and they did no analysis, and I don't understand how a prohibition against discharge is ambiguous. And furthermore, I don't understand how it would be a reasonable interpretation of a prohibition against discharge to allow discharge. And the Court of Appeals did not do that analysis at all. And what I thought was interesting is that there was no justice, nor did the opposing counsel try to defend the Court of Appeals opinion on that.
Right. I mean, I would say MPCA and Polymet were silent with respect to the groundwater.
They literally were. And in their briefs, and it does not mean they waived arguments because their briefs talk about it. But in their briefs, which are, 50, 60 pages long, their briefs, 2 pages on the groundwater rule. They do not want to talk about this issue. And they want the court to just say, you know what, yeah, it's okay if you pollute the groundwater so long as you scoop it up later on. I'm sorry, that's a question. Go ahead.
Scoop it up, put it where?
Well, with the containment system, their hope is that they'll treat all of it so that when it goes back into the water on the outside of the containment, it will be clean, pollution free. I mean, boy, you've never
So-
seen cleaner water than what they're
Yeah.
gonna put out there, is what they thought.
So on the one hand, the stuff that isn't collected is necessary for a Maui functional equivalent analysis, but the stuff that's cleaned without QVels with just these internal operating limits is fine to be discharged. Yeah, question.
So are they using clean water?
I'm sorry.
Will they be utilizing clean water to do this?
What do you mean by clean water? Like, I mean, the water that is being
That they
treated.
will be treating it with, is that clean water?
Oh, so, okay, so the question was in Polymet's wastewater treatment system, will they be using water from somewhere else to try to either dilute or clean out that water? And I'll be perfectly honest with you, I don't remember the exact ins and outs of what scientific mechanism they propose to use, because that's part of the Maui analysis, which is going to happen soon. But that being said, yes, they are intending to use water as part of their wastewater treatment system.
Do they have a number of how many gallons of water that they're gonna be using?
Tens of thousands.
And so if they, and the pipeline, you know, they had a permit for 250.
Oh, water, so you're talking about water appropriation permits from the DNR. Yeah, certainly any mine, right, in the construction, you need to dewater, right? So certainly there's going to be, I would imagine, water appropriation permits from DNR with respect to the mine's operation. I would be shocked if there weren't.
Yeah, so there's a couple questions that I want to add from online here. Margot asks, even when liners have been used, they have leached or leaked or breached. And she asks, am I right? And the answer is, Margot, yes, you are. Liners are not 100% foolproof. And I mean, really, nor is anything, because the real answer is don't pollute. The real answer is don't mine. So we're in somewhat of a, I think, precarious position, because we have to argue under the law that you need to use the best available technology to prevent from pollution. And the best available technology are these liners. And the reason, by the way, Polymet does not want the liner is because it's incredibly expensive to do it. They're just trying to do this on the cheap. But the law says you have to use the best available technology. That's a liner. And until someone comes up with a better mousetrap, it's going to be a liner. And they've actually required liners on different parts of the project. So that's what we're saying to the court is like, look, they have to do this because that's what the law says. So that's the question about liners. There's a couple questions here from Deborah. The justice's questions, what do you glean from the questions? And she points out, and I think this is a really good thing to talk about, several judges asked about what remedy they should order. When an appellate court says, what relief do you want? Or what, if we're going to remand, what do you need here? That's because they're thinking, okay, what's next? Like, I understand there's a problem. I get there are issues here, but how do we try to fix it? What can we do? Appellate courts actually have somewhat limited power as to what they can do. I think one thing generally, it's not unexpected that justices would ask questions about remand, because that's what they're always thinking about. But I think particularly here, they were very focused on whether the reversal should reopen the public comment period completely, which is what we were asking for, or whether it should just reopen the public comment period so that EPA comments can be submitted. And I think they're thinking like, should we reopen it for 10 days? Should we reopen it for 5 days? And something like
And
that.
furthermore, I mean, you know, and what EPA comments will be submitted? Is it the draft comments from 2019? Is
Right.
it, you know, and there was a question to that effect. Would it be this EPA's administration that would file those comments?
And I think that and here's what I take from that. I think that means that there are several justices who are in fact thinking about some version of a remand. Maybe not exactly what we asked for, but I think there is reason to be optimistic that we're going to get some sort of a win out of this. And I'm going to define win as something is in the way of Polymet getting the permit. There's more process has to be done, more questions have to be asked, and most importantly, have to be answered by the agency. I think there's some reason to be optimistic about that. I think that's a lot of the justices. I think that because the justices are thinking about ordering a remand so that there's a 10-day period in which EPA comments can come in, and then MPCA has to respond to them. That's what I think. I'm hopeful that there's also going to be a remand to fix the groundwater issue, that would have to be a brand new permit that would require liners. And so this is all in addition to that Maui analysis I was talking about earlier. They already have to do that. This permit already has been remanded to the agency. And so it's really a question of what exactly does the agency have to do once it goes back to them?
And I'm surprised that didn't come up in one of the answers. This is already with the agency. There's no prejudice to the agency. I know that was in the briefs.
Yeah.
So at this point, maybe it's best, since it's 12:45, to skip the Q-Bells issue in detail and skip MPCA and Polymet's arguments and sort of go to the questions from the court and sort of point a couple things out. Hot bench. What is a hot bench?
Oh, that's a good question. When we talk about appellate courts or just courts in general, if you have a hearing or an argument before a court, that is your opportunity as a lawyer and as a party to talk directly to the decision maker. You do not ever get that opportunity any other time in any other government venue. And so you have to be very focused, you have to be very prepared. And what you're really hoping for is that the justices or the judge are asking you questions. And a hot bench are justices who are asking you questions. And even if the questions are hard to answer or very difficult questions or make you uncomfortable, that's actually a very good thing, because a hot bench almost always means an engaged bench. It's because they care about these issues. They've read, by the way, I guarantee you, they have read all of the briefs several times. They have several clerks who work for them who are recently graduated law students whose sole job is to pour through these briefs and pour through this record. And so everything we've submitted to them ahead of time has been studied very carefully. And the fact that they came ready with questions means that they are intellectually piqued by this. They think that something needs to be decided. This is not just something you should ignore. I will be honest with you, I have been in front of a cold bench before, and there is no worse feeling than arguing to a bench of judges who are not asking you any questions because you're thinking to yourself the entire time, I messed up before because they don't care at all about this. And you start doing things like, a question might be, asking yourself questions to kind of get them involved. And usually what you see in front of after a cold bench is a 2 to 3 page long unpublished opinion affirmed.
Yeah.
And that's it. So I also do think that the fact that this was I would not call it a hot bench as an aggressive bench. I don't think they were upset with any of the lawyers, but they were definitely engaged with everybody. I think that's a good sign for us as well.
What was the most surprising question this morning, whether it was asked you or somebody else? Something that you didn't sort of expect, or
the most surprising question, and the question I was happiest, was when Justice Thiessen asked, before I could even mention groundwater, when he asked questions about the groundwater rule on his own.
Yeah.
I thought that was a very important data point for us to consider, because that means that he was ready to go
for sure
on that issue.
Yeah.
Because usually, and you heard it today, like a lawyer will get up and they'll say, may it please the court, I'm going to talk about A, and then B, and then C, and then kind of gives a spiel. And I didn't get that opportunity, which by the way is fine. I was immediately asked questions about MAPPA and what was going on. And then after I finished answering that question, then Justice Thiessen on his own asked about groundwater. And so again, I thought that was surprising and important. I was actually kind of expecting the justices to be kind of like, about groundwater.
And not only about groundwater, but ask a question that got to the very heart of the variance issue, right?
Yeah.
And other tailing spaces, which allowed for you to explain, the plain meaning of
Right.
the rule.
Right.
So I think that was great.
I think that the question, and I think we all should think about this a lot, because we knew this question was coming, and it was the first question from the bench, was essentially EPA could have submitted comments no matter what, and they didn't. So does what MPCA did even really matter all that much? EPA could have objected to the permit, and they didn't. So does what we're talking about today matter all that much? And I want us to think about that, because I'll be blunt, that's how we lose. Because it's a fair point. This court has no jurisdiction over the federal EPA, and the MPCA has no jurisdiction over the EPA, and EPA can, if it wants to, do not really whatever it wants, but it doesn't have to submit a comment. That is true. And so if we do lose on this issue, it'll be because at least 4 justices think there's really no problem. What MPCA did is wrong, but there's no problem because EPA could have just simply ignored that request.
Yeah, and I think it's easier to sort of brush things aside and make, MPCA's actions redeemable if you look at each piece of conduct on its own. When you look at it holistically, right, it's much harder to forgive MPCA. It's clearly in this action was trying to campaign EPA not to submit written comments. It would have caused bad press, and it would have caused a heartache in terms of responding to those comments.
Right, and again, would have caused bad press for Polymet.
Yeah. So who do you feel got the harder questions? Who do you feel like the court was a Polymet, MPCA, Friends, and Water Legacy and its partners? I mean, who is the court sort of focusing its gaze on?
I think the one thing was clear is that several justices even directly said to PCA what PCA did was wrong. There's kind of no question in a lot of the justices' mind that what PCA did was wrong. And so when actually, I'm just going to take a quick second here because I want to say this. I say this to my clients all the time. If you don't like opposing counsel, it's because they're doing their job. So like we're all sitting there and it's like, oh, that Bryson Smith guy, or G Johnson, they're fine human beings, but they say ridiculous things. And the one thing that he said that was ridiculous, Bryson Smith, in my opinion, was he went on for like the first 2 minutes about, we've been working on this permit for so long and it's been 13 years and man, and we did this whole EIS
and more than that, though, greenwashing. I was sort of shocked at the greenwashing, right? I mean, it's like, we need these precious metals, we need to do this. I mean, it started out with a strong message of greenwashing and how much work had been done and why, why these are technical violations that don't matter. We need these minerals.
Right.
It's
And
a sense like that.
And I think that so the hardest question that they got was not as much a question as it was a direct rejection of that position when they were saying things like, come on, this wasn't just some staffer,
Right.
this was like somebody important with the EPA. This wasn't just some small issue. This is a big deal. So that was important. Go ahead.
13 years ago, we weren't looking for things for the green environment.
Right.
So none of that was even looked at when they started wanting to do this.
Right.
And of course, we don't know if the EPA is saying, we're going to be saying, you shouldn't be able to put a permit on here. And we held that back on the request of our state agents. Because we don't know what it was.
Right. And so the question or the comment was, and if I don't fairly summarize it, please let me know, was the 13 years ago, there wasn't some huge push for copper in terms of it being good for the green economy. There may have been some of it, but that wasn't the reason. And fundamentally, 13 years of hard work and looking at something isn't how permits are judged. This is not an A for effort standard of law. You could have spent 45 years on a permit. If it's illegal, it's illegal. And that was one of those things where I like wrote it down in my notes and just didn't get a chance to refute it. But I think the justices get that, because one justice, asked about that standard of arbitrary and capricious being a hard look, right? And I think the question was asked to Paula. They looked at this for 13 years. Isn't that a hard look? And I think Paula's answer was very good. And said, like, look, what matters is in the moment. Like, whatever happened before is different. What happened in the moment when they issued this permit, they didn't take a hard look.
Yeah.
And that's what counts. But I'll let you know that we've been working so hard at this for 13 years has been their theme in every case that we've gone against them. The DNR said the same thing. Polymet says the same thing. This has been the most reviewed permit, and again, like, that may be true, but it also doesn't matter. What matters is whether it's illegal or not.
Are you surprised that, sort of two questions? Are you surprised that the EPA's comments in the core section 404 permit came up, right? And then second question, do you feel like, based on the questions about the OIG report, that the Supreme Court is going to allow that in?
Well, I think there's definite interest from the justices about what EPA's comments would be and what EPA's position is as to this permit. And those EPA concerns go right to the heart of the draft comments that would have come in and didn't, and they go right to the heart of what Paula was talking about. When Justice Thiessen was asking about EPA's comments in 2022, those comments were critical of PC's interpretation of the Clean Water Act, and that's a really hard question for them, because they have to take this kind of lawyerly dodge about the whole thing, like, well, that was some other proceeding, that wasn't the proceeding before us. It doesn't change the fact, in a practical sense, that this is the same EPA who was going to say the same thing about your project that we're here about right now. So I think there's we always say you can't unring the bell. That's a phrase you'll hear a lot of lawyers say. And oftentimes that's like in a jury trial. Like if the jury hears something, the judge may say to them, you should forget that, but it's really hard for a jury to intentionally forget something, right? Well, no different for justices in the Supreme Court. They're humans, you guys, they're humans. And the fact that they know that EPA is concerned about this, you can't unring that bell. So even if we lose the OIG fight, I still think it helps us because it underscores that, look, we're here because of something important.
And I think it also underscores, one of the questions was, how do we know MPC or EPA is going to submit a comment, right? The fact that they're commenting this strongly in the section 404 permit, I think should show the court that this is an engaged EPA. They need to be given an opportunity to submit comments critical of the permit.
And look, I mean, behind the scenes of this entire thing, and Paula did a very clever job of referring to it as the prior administration. This whole thing is because the Trump administration EPA was pro-mining. I mean, this was like first day in office kind of stuff for the Trump administration. And that's what happens with these agencies. This is why we say things like elections matter. The current EPA, the Biden administration EPA, is much more likely to be pro-regulation and pro-environment. Now, if this case were to happen 3 or 4 years ago, and we'd be saying you should remand so the Trump administration can issue a comment, I mean, what are we doing?
Yeah. So we're in time. Before I thank Evan, I want to say, give a plug for Prove It First, as Paul was discussing earlier. It's, common sense. Before a copper sulfide mine can open in Minnesota, it would require independent scientific proof that the mine is operated elsewhere in the United States under similar circumstances, right? Similar environment for 10 years and been closed for 10 years. without polluting. We're active through, advocacy in the courtrooms as well as in the legislature. Thank you so much to Evan for coming in and agreeing to do this, especially after preparing for oral argument and getting grilled. We really appreciate it. We appreciate all of you. Thank you
Thank you very much.
for the
everybody.
wilderness.
Thank you for those of you online as well.